In 15 minutes, President Obama will sign the federal health care reform bill, and it will have immediate enactment. At that point, we believe the federal government will be acting illegally outside the scope of its constitutional authority. The federal health care reform bill will regulate 1/6 of our economy on both the supply and the demand side. It is an encroachment upon the powers reserved to the state of Minnesota and its residents under the 10th Amendment of the U.S. Constitution. Within that bill, there is an unconstitutional individual mandate forcing Minnesotans to buy insurance. There's also a violation of the per-person tax clause or the capitation tax clause in the Constitution with the shared responsibility penalty. The alternative for Congress was not nothing. They could have adopted a constitutional plan instead of the unconstitutional scheme. They could have raised income taxes. They could have imposed or provided a tax credit for folks. But what they've adopted is an unconstitutional scheme that will be struck down in our courts. The battle will move to our courts. So this morning I hand-delivered a letter to our state's Attorney General signed by 68 state legislators from Moorhead to Mankato, all calling on our Attorney General, Swanson, to file a lawsuit immediately to protect the interests of all Minnesotans and the state of Minnesota. This is an assault on our Constitution. Our Attorney General needs to step up and act immediately. In 16 minutes, or by the end of the day today, Attorney General Ken Cuccinelli of the Commonwealth of Virginia will file a lawsuit in the Rocket Docket, the Eastern District of Virginia. 12 attorneys general from states across the country will either file their own suit or join one of these other federal lawsuits. That includes our neighbors of North and South Dakota and Nebraska. The governor's letter of yesterday to our Attorney General, and ours as well, makes clear the interests of the state of Minnesota are directly affected by the legislation, financially, in terms of its policy, and also in terms of the Constitution. Minnesota Statute's 8.01 mandate that our Attorney General appear in court where our interests are directly affected. And as I've said, we have laid out the case for her that they are now directly affected. Minnesotans insist that our Attorney General lay aside her political agenda, which clearly has gotten in the way of her work. She is our attorney. We are her client. She has essentially been on our retainer for the past 3.5 years. She may not agree with our goals, but we raise meritorious claims. We clearly have laid them out, and now she has a responsibility to act. In her letter of yesterday, responding to the governor, she says that she has not had time to review the 2,400 pages. First, there's 2,700 pages, but we find that oddly ironic, her response. Nonetheless, the U.S. Senate passed the provisions that we're talking about, the illegal provisions, on December 24. The Association of Attorneys General has provided resources available to her since that day. We have provided sufficient legal resources, a wide range of resources in her office available to monitor our state's interests. Our Attorney General should be ready now. We call on her to act immediately, to state her position so we can then act accordingly. I did invite her to this press conference this morning. I think there will be many challenges. This is the start. The lawsuit to be filed in the Commonwealth of Virginia, the Eastern District, will have additional claims because in Virginia they acted early to say legislatively, and the governor has signed a bill that says that they will not allow the federal government to step in and manage this issue or regulate this issue. So they have additional claims in Virginia. There may be others in other states as well. There certainly are some policy impacts that we're working on. The implementation may itself raise some constitutional questions. There may be other options for all of us, and that's what we're doing now, is exploring all the options about whether we can join with or without her, whether we can insist that she file. There is as I said, Minnesota Statutes 8.1 has a mandate that if the state's interests are directly affected in a lawsuit in federal court, she must appear. And that's what we're looking at now, is what are our options. So that's why we're saying to her, please come forward and state your position so then we can act accordingly.
So, you just handed out literature calling for universal health care.
Well, I would say that her political agenda has gotten in the way of her responsibilities to serve the residents of the state and the state of Minnesota. And it is of great concern to Minnesotans because she is our attorney. She was hired to be our attorney, and once in that office, she really had a responsibility to be acting in a nonpartisan fashion. Depends upon the severability question, which the courts will look at again to determine whether Congress's intent was to make it severable or not, meaning the court will look to decide whether if you strike down the one unconstitutional provision, if the entire scheme fails, or whether the remainder continues with the force of law. That's a terrible result for us as well. If all of the mandates and the benefits continue, but the sources of revenue are struck down by the court, that could create chaos. I mean, we don't want that either. So we will be arguing very strenuously for the non-severability. Excuse me, severability.
To get rid of the entire bill.
Yes.
And not just that
Yes.
one part.
Yes. And I would just follow up on what Representative Seifert said. The U.S. Supreme Court has more recently taken a more limited approach to the Congress's power under the Commerce Clause. There were two recent cases that you might be interested in where Congress attempted to regulate non-economic activity, and the Supreme Court said that Congress encroached upon the 10th Amendment rights of the states to regulate those activities. In particular was the ban on guns on school premises and the Violence Against Women Act. The Supreme Court held them to be unconstitutional provisions in congressional legislation. So that's part of the precedent that we have going forward. We expect that the Supreme Court, if they're given a chance to opine here, will say that there is a limitation to the commerce power. It's been overreached here, and the state's rights to regulate this area continue. That. There may be very legitimate policy goals in this legislation. That's not the point. There is a constitutional method available for responding to those and addressing those policy concerns and accomplishing the goals. But what the Supreme Court will look to is to say, have they done it in a way that has offended the Constitution? And in this case, yes. Was there, and the Supreme Court will ask this, with their scrutiny, they will say, were there other means available that were constitutional to accomplish these goals? And we are all here to say, yes, it would be the more straightforward, raise the income tax or tax credits. So what they're doing really is taking it away from what has been the traditional way to provide for the general welfare of the residents of the United States and adopted this really contorted scheme to avoid that. Well, number one, we all have a duty to support the Constitution. Every elected official here at the state level does. All the House members, state Senate members, the Attorney General, the Governor have all sworn the same oath to support our Constitution. But secondly, the whole concept of the 10th Amendment allows for what's called the laboratory of the states. In our constitutional republic, we have 50 different ways to resolve health care issues. We have our way in the state of Minnesota. We think we're serving the residents very well. We have community interests that may be different than in some other state or across the country, and that's why we have an interest because our laws are different here. We believe we have a very good system of providing health care for the residents of the state of Minnesota. I think the GAMC fix that we've all been working on is an outstanding reform. That's the interest we have. And there are hopefully some future chairs of healthcare policy committees in this room that will have a future in deciding some of those issues and leading that issue, where right now it looks like the Democrat chairs are ready to give up their authority and turn the entire issue over to the federal government. We absolutely have an interest in the outcome of this lawsuit that is different than every other state's interest. I would say that we have moved to a couple of different venues. Number one, the courts. The battle is clearly going to be waged there. In the U.S. Senate, where it's not clear that the Senate will repass the reconciliation provision, so I think you're going to see a lot of politics around that. And then I do think that you're going to see repeal momentum and then also elections. I do think that this will be a huge election issue across the country. Frankly, it's about the Commerce Clause. When Congress passed its Social Security laws, it was under the general welfare clauses in the Constitution. What's going to be signed today relies upon the Commerce Clause, which is a very different line of authority for Congress, and that's the line that we're talking about today and the line that they've crossed over. That's exactly why we're asking our Attorney General to state her position now, so that we can review all of our options and decide what our next steps are. But we are not done with this. We will wait for her to step forward and do her work. If she will not, then we will engage in this.